All right, everybody, get ready, cause today we are going deep, deep into the world of property law.
Oh, yeah.
Easements and covenants. They might not sound like the most exciting topics.
Right.
But trust me, once you peel back the layers, it gets really interesting.
It really does.
And for those of you learners out there who are all about, like, you want the knowledge,
Yeah.
you want it fast, but you want it thorough.
Yes.
This is going to be right up your alley.
Absolutely.
We've been digging into this property law textbook, chapter 8.pdf. And let me tell you, some of this stuff even had me like scratching my head.
Yeah.
In a good way,
Yeah.
Like, for example, did you know there are easements that aren't even written down?
Really?
Yeah, we're talking like invisible easements.
Oh, wow.
For things like underground utilities.
I
And get this, you might actually be able to move an easement.
What?
I know, right? Don't worry, our expert is here to break it all down for us.
I'll do my best.
So let's start with the basics. Like, what is an easement? Why should we even care about this?
Easements, they're all about access.
Uh-huh.
It's the legal right to use someone else's property for a specific purpose. So think of it like an agreement, a legal agreement that lets you do something on land you don't own.
Okay.
And here's the thing. That agreement, it can stay in effect even if the property changes hands down the line.
Oh, wow. Okay, that makes sense. But the book talks about different types of easements.
Yes.
Like easements by necessity, easements by implication. Those sound kind of intense.
Yeah.
What's the difference?
Easement by necessity. It does sound kind of dramatic, right?
It does.
And in a way it is. Imagine a piece of land that is totally landlocked. No access to a public road or anything.
Oh.
An easement by necessity could be granted by a court to make sure that owner is not stuck.
I see.
Easements by implication, those are a little more nuanced.
Yep.
They don't have that sort of, spelled out in writing thing, but they kind of come out of the history of how the land has been used. And a fascinating example of that is this case, Lobato v. Taylor, where you had settlers in Colorado, and they were relying on these unwritten agreements to use common land that, for generations.
Wait, hold on. Unwritten agreements?
I know.
That sounds like a recipe for, like, a legal showdown.
Right.
So what happened in that case? Did these settlers actually get to keep using the land?
It's a classic example of where property law gets into, like, history and these community dynamics. So this case, it was centered around this area, the Sangre de Cristo land grant in Colorado. And for a long, long time, the settlers there, they relied on being able to get to common land. We're talking for grazing, for timber, all sorts of things.
Right.
And these agreements, they weren't like, officially written down. It was just this accepted part of life there.
So it was like this kind of unspoken agreement. Everybody just went along with it.
Yeah.
That's kind of risky, though, isn't it?
It is. And that's where things got messy. So fast forward, we're talking late 20th century. A developer comes in and tries to restrict access to this common land.
Oh.
And that is when the descendants of these original settlers, they sued. They're like, we have rights here based on how this has always been done.
Oh, wow. Okay, so I'm seeing where this is going. It went to court, right?
Of course it did.
What the court have to say about these, like, implied easements?
The court actually sided with the settlers in Lobato v. Taylor.
Oh, wow.
They ruled that even though, nothing was like formally on paper, the fact that this is how the land had been used for so long, that created this legally binding easement, an implied easement by prior use.
Wow. So the court basically said, hey, even if it's not on paper, everyone's been doing it this way forever, so it's got to count for something.
Exactly.
It's a big deal, right?
It is a big deal. It really acknowledges that sometimes history and those long-held practices, they carry as much weight as, some fancy written contract.
Mm.
But as you can imagine, this whole idea of an implied easement, well, it can lead to some pretty tricky situations.
Oh, yeah. Okay, I can definitely see that. This Lobato case has got me thinking, if an easement's implied, how can anyone really be sure what it covers?
Right.
Like, how much can you actually do with an easement?
Right.
And what about that example from the with the road dispute? What was that all about?
Oh, yeah. That's the thing about easements. It can be tricky determining that scope, whether it's written out explicitly or it's one of those implied ones.
Right.
It all comes down to, like, how was it created and then what's reasonably necessary for the easement's purpose.
Okay.
And that road dispute is a perfect example.
Yeah.
So the source material, it talks about this case. There was an easement for this property, right? And it was access through this narrow, unpaved road. And the property owner, they wanted to widen it, make it a little more accessible. Sounds pretty reasonable, right?
Yeah. Yeah, it does.
Well, the court actually disagreed.
Oh, no, really?
Yeah, they ruled that actually widening the road, that was going beyond what was originally meant by the easement. Like it was never intended for that.
Wow.
And it would put too much burden on the owner of the other piece of land, where the road went through.
Oh, that makes sense. I see. So even if it seems like, oh, this easement's pretty straightforward,
Sure.
there's all this like legal gray area around it.
Exactly. So,
Yeah.
word to the wise, if you're thinking about buying a place, do your homework right.
Mm-hmm.
Look for any easements on the property, even those ones that might not be super obvious or even written down.
Mm-hmm.
A good real estate attorney can really help you navigate all that.
Oh, yeah. It's all about being in the know. Okay, so we've talked about easements, these like sometimes hidden easements.
Right.
Let's switch gears a little bit, talk about something that seems, I don't know, less dramatic maybe on the surface. Covenants.
Okay.
And I was thinking about this, right? Like a good analogy for covenants is they're like the ground rules of a neighborhood.
Okay.
But like with legal teeth.
Right.
It's not just like, oh, we do this here. It's like, no, this is actually legally binding, which I don't know. I think it adds a whole other layer of kind of intrigue to it.
Mm-hmm. It does. It's fascinating. So, these covenants, they cover all kinds of stuff, how your house can look, whether you could park like an RV in your driveway. It runs the gamut, but they're legally binding.
Wow. So these aren't just like friendly suggestions from the neighborhood association. It's like,
no.
An enforceable by law.
Enforceable by law.
Yeah.
And they run with the land.
What does that mean?
So it means that it's not just binding for the original owner, but it passes on to all the future owners too.
Wow. So you're not just buying a house and land when you buy a place with covenants. You're buying into like a whole set of rules that are going to outlive you.
Exactly. Which you can imagine leads to some pretty interesting situations, legal battles even.
Oh.
The source material, it talks about this one case where an architect put all these really specific, unusual restrictions on the design of homes in this subdivision he was developing, right? Trying to control how they look.
Wow.
And it makes you wonder, can a developer really do that, even after they've sold the property?
That sounds like a homeowners association nightmare, honestly.
Oh, yeah.
Speaking of which, the book also mentioned this case about a town trying to ban alcohol sales.
All right.
Even though, like, everyone was bringing their own booze to events anyway.
Right.
How do courts decide, like, when these rules are just outdated or, like, unreasonable?
That's where this whole idea of reasonableness, it comes into play when you're talking about enforcing covenants. Courts are going to look at things like, what was the original intent of this covenant? Does it still make sense? Is it still serving a real purpose? And is it unfairly burdening the property owner?
Okay. So it's not just like, is this rule old and weird? It's like the court actually looks at the bigger picture, how it affects people, but who gets to decide what's reasonable?
I know, right?
That seems kind of subjective.
It's not always clear cut, but courts rely on, legal precedent and these principles to guide their decisions.
Okay.
And the source material actually has some super interesting cases that show this in action. Like there's the Davidson Brothers supermarket case. It's kind of a classic when you're talking about covenants.
Okay, you gotta tell me more about the Davidson Brothers. What's so special about that one?
So Davidson Brothers, you've got the supermarket owner. They're selling one of their stores, and they slap a covenant on it that says the property can't be used as a supermarket for a certain number of years. So, no competition. Pretty standard stuff, right?
Yeah, you see that all the time with businesses.
Exactly. But here's the kicker. This particular property, it was in a low-income neighborhood that already had very few options for fresh food.
Oh, no.
So when this covenant blocked another supermarket from opening up, instant food desert.
Wow. So this rule that seemed like totally normal on the surface had this like ripple effect on the whole community.
Exactly. And the court actually recognized that. They know this covenant is unreasonable. It went against the public interest. They understood that access to affordable food, that's a major concern. And this covenant was getting in the way of that.
That's incredible. So something that seems very straightforward can have these like unintended consequences.
Exactly.
It makes you wonder how many covenants are out there just like quietly shaping our communities in all these ways that we don't even realize.
All the time. And it brings us to another interesting case from the reading, Narstedt v. Lakeside Village. You might know it as the No Pets case.
Oh, the No Pets case. The No Pets case. That one always sparks debate. Remind us what happened there.
This case involved a woman who sued her condo association because they wouldn't let her keep her 3 cats in her unit, citing the condo's no pets rule.
I bet that case had everyone picking sides.
Yep.
So what happened? Was the no pets covenant considered reasonable?
In the end, the court sided with the condo association. They decided the pet restriction was reasonable and enforceable, arguing that in a condo development where people live in close proximity, pet restrictions are a legitimate way to maintain a peaceful and sanitary environment for everyone.
But what about people who argue that their pets are well behaved and stay confined to their own units?
That's where things get tricky. The court said you can't determine the reasonableness of a covenant on a case-by-case basis. It has to be applied consistently across the board.
This whole concept of reasonableness is fascinating. It's not always cut and dry. And the reading mentions something called the restatement. Third, what is that and why should we care?
Yes. The restatement third is essentially an effort to bring property law into the modern age, to clarify things and make it more relevant to today's world. It's like a guide for courts, offering a more adaptable framework for evaluating covenants and taking into account factors like public policy and how societal norms change.
So it's like they're acknowledging that what was considered reasonable 50 years ago might not be the case today.
Exactly. It recognizes that our understanding of what's reasonable evolves. It doesn't magically solve every legal dilemma, of course, but it's a step towards creating more clarity and fairness within property law.
Makes sense. Now, you mentioned earlier how court interpretations can differ when it comes to reasonableness. Are there any examples of that?
Absolutely. The source material highlights a great example. The case of political signs in a homeowners association. Some courts have upheld restrictions on political signs, arguing that it helps maintain a sense of visual harmony and prevents conflicts within the community. Yeah, things can get heated during election season. I can see why a homeowners association might want to avoid that.
Right. But here's the other side of the coin. Some courts have struck down those same restrictions, saying they infringe on people's First Amendment rights to free speech. It just goes to show how the judicial interpretation of covenants can vary, and why having legal expertise is crucial in these situations. It's a good reminder that property law is rarely black and white. We've covered a lot of ground today, from those invisible easements to the ongoing effort to modernize property law with things like the restatement. Third, if you had to pick one takeaway, the most mind-blowing piece of info from this whole deep dive, what would it be?
That's a tough one. But if I had to choose, I'd say the concept of implied easements is pretty significant. It highlights how property law often reflects social customs and historical practices, even when they're not explicitly stated in a legal document.
The Labader case, with those Colorado settlers fighting for their rights, really brought that idea to life. It reminds us that property rights aren't always straightforward and that history plays a huge role.
Precisely. And for someone like you, always eager to understand how knowledge applies in the real world, I think that's a key takeaway.
Absolutely. Speaking of real-world application, let's say you're about to jump into the world of property ownership. Maybe you're getting ready to close on a property, or perhaps you're attending a community meeting where these very topics will be discussed. How would this newfound knowledge about easements and covenants change how you handle yourself in those situations?
I'd say the most important thing is to be proactive. Don't just passively nod along or accept things at face value. Read every single word of those documents, take a good hard look at those property surveys, and don't be shy about asking questions even if they seem basic. You'd be amazed how often disputes arise from misunderstandings about easements and covenants.
Such great advice. Knowledge is power, as they say.
Exactly. And remember, a little bit of legal knowledge, even just having a basic understanding of these concepts, can be incredibly empowering. It can protect your rights and help ensure you can fully enjoy your property.
Couldn't agree more. Okay, before we wrap things up, I have one last question that's been on my mind. We've touched on how the law is evolving, trying to keep pace with our modern world. But what about the future? Our source material barely scratched the surface of how technology is changing how we live and interact with our homes and communities. Think about virtual reality, for example. What happens when home isn't just a physical space, but also a digital environment? Will we need easements and covenants in the metaverse?
Now that is a fascinating question. And to be honest, it's one that has legal scholars scratching their heads right now. How do you define property rights in a virtual realm? Can you have an easement for a virtual pathway or a covenant that dictates what your digital dwelling can look like? What happens when the digital and physical worlds collide, as they inevitably will? These are questions we'll be grappling with more and more in the years to come.
Wow, talk about a deep dive for another day. That's something to ponder for sure. But for now, I think we've covered a lot of ground, and I'm confident you're well equipped to navigate any property law puzzle that comes your way. Thanks for joining us on this deep dive. Until next time, happy learning.